What is the difference between the types of letters in a probate real estate sale? You maybe saw our other video about what are the letters in a probate real estate sale. But what are the different types and what does it mean? We'll get to that right now. Welcome back to the channel. I'm Brendan Mohr, California Realtor and Certified Probate and Trust Specialist by the California Association of Realtors.
And I'm Bill Heyman. I'm a licensed professional California fiduciary. I'm also a licensed California real estate broker, a licensed Nevada realtor, and I'm a bonded and registered legal document assistant in both California and Nevada.
Now, please like our video right now, subscribe to our channel. Want your probate done for little to no cost? Well, every day we help people save thousands of dollars and eliminate headaches with our one-of-a-kind probate administration service and real estate listing combo. So please reach out to us about that, or reach out to us with any questions about probate real estate. Comment on this video. Our contact information is below, so please email, text us, call us, because we can help you. So Bill, what are the different types of letters when it comes to probate real estate sale or probate in general?
Sure, Brendan. There's essentially 4 different types of letters. So let's start with the letters testamentary. Letters testamentary are what the court issues in terms of letters when you're submitting a will. There's a will in the probate process, and there's a named executor in the will, and the named executor in the will is going to act as the executor. In that situation, when the court issues letters, they will be letters testamentary.
And now the next one is maybe the one we see most common, letters of administration.
Right. Letters of administration, you're right. Those, I would say we probably see the majority of the time. That is essentially when there's no will. No will exists, no will is going to be admitted to probate, and someone is going to be in charge of the estate, and in that case, letters of administration are issued. And usually the administrator, it could be a family member, an heir, could be a professional fiduciary or something like that.
In fact, I've seen it on multiple occasions where you were the administrator. I really like that because I get my documents signed very quickly and I don't need to explain the process. That's fine. Explaining the process is part of my job. It's just great when somebody who really knows the process is involved. Yeah. So if you ever find yourself really confused about the process or not too sure, it's great to have somebody who is a professional fiduciary maybe being that administrator.
And just as a side note, when a family does decide to have me act as the administrator, I do it at no additional charge to the client. So there's no additional fee at all.
It really kind of makes it streamlined and easier.
Yeah.
Now, another one that I've seen actually you be before, special administration.
Yeah, letters of special administration, that's really reserved for situations when there's kind of an emergency type situation with the estate. An emergency being maybe the probate home is in foreclosure and you need someone to be able to communicate and talk to the lender and the trustee ASAP to try to negotiate to forestall that foreclosure. So you get letters of special administration where the court gives an order that you are authorized to basically talk to the lender on behalf of the estate. Another situation is maybe you have a probate where there's an ongoing business and that business needs to continue to run. Well, you can't always wait a month, 2 or 3 for that initial hearing, and the business needs to continue to run, so you get letters of special administration. And the court basically gives you the authority to be in charge of an act for the business to keep it running smoothly. So those are there's other situations where you might want letters of special administration, but those are 2 of probably the more common ones.
I want to circle back to a little bit on that one a little bit later, but this last one, letters of administration with will annexed.
Yeah, that's one that, just from the sound of it, kind of confuses people. But essentially what that is, these are letters of administration. They're issued by the court when, for example, maybe you have a will where none of the named executors in the will are going to act. Maybe they've passed on, or maybe they've just declined to act. Or maybe the will, for some reason, didn't name an executor at all. So what happens in that case is someone else will act as the administrator, again, probably a family member, an heir, possibly a professional fiduciary. But they'll act as an administrator, but the will still be admitted into probate, and the distribution plan for the estate will be according to the will. That's really what letters of administration with the will annex is.
Now, I bet a lot of people are watching this because I get this all the time, and we've had videos on this. We've talked about it in other videos. You mention a will, and a lot of people think, well, we have a will. We don't have to go to through probate, do we?
Yeah, that's another one. A big misunderstanding is no. A lot of people think if they have a will, it avoids probate, but it doesn't. In fact, a will practically guarantees probate. One of the better ways to avoid probate is a living trust, and that's maybe something at some other time we can talk about. But yeah, you're right.
We do actually have a video on that. I think it's called, and we've done a lot of videos. Mm-hmm. So sometimes I forget even that we've done certain ones, but I think it's called How to Avoid Probate.
Yeah.
So Bill, what is the court's role in this?
Sure. Well, basically the court's role is to oversee the whole process and really kind of just make sure that everything that is required to be done by the probate codes is done. So essentially what either the proposed administrator or executor and the probate attorney or probate professional service like us, what essentially they're doing is from the time that initial petition is filed until that first hearing, they're getting everything in order, making sure all the paperwork that the court requires has been filed so that it's in the file by the time that first hearing rolls around. And basically the judge, and there's usually what they call probate examiners, so they can look in the file and they can go just down their list and check off boxes saying, is the petition here? Is it correct? Yes. Is the notice of petition here? Yes. Is the prepared order here? Are the prepared letters here? Has the publication for the notice been done correctly? That's basically all they're doing. And as long as you have that done correctly, they're going to approve the letters and issue them at that first hearing date.
So when it comes to filling out the letters, it's not really the court that checks the box for whether it's letters testamentary or of administration. It's whoever's preparing the document and really the one probating the estate, the probate administration service. Sometimes that's an attorney, sometimes that's a professional fiduciary like yourself. So sometimes there are mistakes made on that document, which I've seen before where actually an attorney's office has made mistakes on a document and they had to go back to court and
get it corrected.
Yeah.
It happens.
So that is one thing to know, especially if you're doing it on your own, that you're the one. If you're doing it on your own, you're the one who has to actually check that box,
right.
And know which type to put. Now, I wanted to circle back to some of these letters testamentary and letters of administration. Those typically take about the same time to get in front of the judge, right? And then, of course, the letters will grant full or limited authority. But then there's special administration. And you mentioned that that's more for emergency situations. Like, right. We have to get this going fast.
Yes.
This is an emergency. Yeah. How much faster?
A lot faster.
Yeah.
When you go to the court to ask for letters of special administration, you usually will do it by a process that's called ex parte, which is really just basically doing something without a formal hearing and without formal notice and all that. And depending on the court, you can usually get it done within 1 to 5 days. It's a very fast process because it is an emergency situation. The court knows that, so they have a special time and special days to get that done. The thing you have to do when you're doing that is you still have to try to give notice to all the interested parties. Generally, you either do that by telephone, you either do that by email, possibly by fax, but you got to describe to the court in the forms when you apply for that special administration letters. You got to describe what you did, the phone calls you made, and you got to describe the results. I talked to John Smith, and he said he was fine with it. He had no problem. I talked to Joan Smith, and she said, "Oh no, I don't want you doing this." You got to report that to the court, and if you do get an objection from one of the the heirs or interested parties, the court might not grant it.
Well, I know that I've seen you as the special administrator before, and it was it was an emergency situation. There was I've seen it at least once before. I don't know. We've done a lot of probates together, but the one most recently, there was a foreclosure involved, and even the heirs didn't really understand how important it was, or that this particular document gave you that authority to talk to the lender.
Yeah.
And that's one of the things that the letters really do, right?
Yeah, they do. Because once I had gotten those letters of special administration, that just opened the door to the lender and the trustee, and I could communicate with them, and I could let them know what's going on, that we're attempting to sell the house. You're going to get a full payoff. You just need to give us time, and we were able to work that all out. Without those letters of special administration, that house might have been lost to foreclosure.
And lenders know what's going on when they're seeing this particular court document. It's a standard court document. It's not some weird looking thing they've never seen before. They've dealt with this a lot.
Right.
So they know that gives you authority, whoever is granted authority, to speak with the lender. So if you're going through a situation where the lender won't talk with you, and you have your letters, make sure to let them know that you have been appointed, or whoever has been appointed, the administrator or executor in that case.
And one other thing too about those letters of special administration, sometimes, especially because we do deal quite a bit with probate homes that are in foreclosure, but sometimes when you send a copy of those letters of special administration to the lender and to the trustee, and it has the judge's signature stamp on there saying that, you know, this person is hereby ordered to communicate with the lender about the foreclosure. Sometimes that puts a little fear in them and might help you to get that foreclosure date postponed. It can be a help, in addition to your communicating with them and letting them know what's going on.
Yeah, that's all great advice, and we'll probably expand on some of this in later videos.
Yeah.
So really, what I think that you need to know a little bit more is perhaps hiring the right people that will get this document filled out correctly. And we really get into that a lot in a video that touches base with the cost of probate in California and who to hire. So there's a video linked next called How Much Does Probate Cost in California? And we can show you how much it can cost you and how much you can save with bill service, or maybe even doing it on your own. And that is linked next. It's going to appear right above Bill's head.